We have a presenter here on another item that was scheduled for 2:30, and so we're going to skip over for the moment the policy discussion, the fiscal policy discussions, so that the folks that are here on request a co-sponsor amendment to GR9 can make their presentation. I think we have Judge Jeffrey Goodwin here from Snohomish County District Court, and I don't know if I saw the chair of the Rules Committee online, Mr. Rivas. I don't know if he's planning on making any comments about that, but I'd like to hear from him because the committee did send a letter, which I believe is in your materials. So good afternoon, Judge Goodwin.
Thank you. What a pleasure to be here this afternoon to speak with you, and what a pleasure to be here in person as well. I'm Jeffrey Goodwin. I'm a district court judge with Snohomish County. I am the immediate past chair of the DMCJA Rules Committee and a current DMCJA board member. I'm here on behalf of both SCJA and DMCJA to ask you to join as a sponsor and a proponent in an amendment that SCJA and DMCJA will be presenting to the Supreme Court Rules Committee regarding GR9. As we noted in our materials, there have been some challenges related to the GR9 rules process, and for a number of reasons. COVID has been a reason. The breadth of proposals coming from different entities as well has been a real challenge for rules. We're getting proposals from lots of different entities, many of them without a lot of experience in drafting and working with rules. The challenges that we're having under the current process with GR9 is a lack of involvement from the Supreme Court Rules Committee to SCJA, DMCJA, and WSBA. That's required under GR9, and somehow in the COVID process and all of that, we lost that. And it's been, as chair of the DMCJA Rules Committee, I cannot tell you the last time that DMCJA received a preliminary vetting of a suggested rule. The way these rules work is a rule comes in, it's a suggested rule until the Supreme Court Rules Committee decides to publish it, then it becomes a proposed rule. What is supposed to happen under GR9F2 is that our entities are supposed to get advance notice to vet these. The idea is to correct procedural deficiencies largely and practicality issues related to the implementation of these rules, to provide feedback to the Supreme Court Rules Committee so that a better product can then go out for comment, and that's not happening. To their credit, the Supreme Court Rules Committee has been very active in the last several months, getting back to, I'm hoping they're doing so with WSBA, but in getting back to both SCJA and DMCJA with some questions about the rules and some dialogue. Our concern is that while this current group of justices is very involved, they won't be there forever. And we're concerned what might happen down the road, and we don't want to revert to the process that caused us problems. We cite a couple of rules in that cover sheet. I'm not going to go through those. There were some problematic issues there. So that's the impetus behind this change. And what we're looking to do is we're looking to change the composition of the Rules Committee and the way the Rules Committee works, the Supreme Court Rules Committee, to ultimately provide a much better product. We want to incorporate the expertise of all of our rules committees to assist the Supreme Court Rules Committee then in coming up with a much better product. The other challenge that I think we're facing is that while the Supreme Court, when it gets to them as a proposed rule, has the opportunity to amend the rule, that rarely happens. And so what we see is we see a rule come in that's very difficult for the trial courts to administer, and it simply then comes out in that format because there isn't anybody there to amend it. The way this process would work then is a representative from each of the three associations would be designated to serve at the pleasure of those respective boards. So for you, it would be a WSBA member. You could choose who that is, the duration of their term, whatever their status was, as far as where they came from within your organization. They would be a voting member on the Rules Committee. The Rules Committee then would have the opportunity to edit and amend the rules, send them back to the proponent for some additional feedback. Then before this rule became a proposed rule and went out for comment. Other than that, the process really doesn't change. It just makes a much more vibrant Rules Committee working to make this a better rule that's going to work well for the trial courts. There is, I think, some concern perhaps from the Supreme Court that if these three entities are included within the rulemaking process on the Rules Committee, there are going to be other groups who wish to be part of that as well. Keep in mind that those other groups always have the opportunity to comment. They also can be notified by the Rules Committee, which would be comprised of our three organizations and four of the Supreme Court justices. If they're an interested party, they can request that ahead of time to receive that notice. So all those mechanisms still exist. Your liaison then is to your entire organization. And so that WSBA member would come to your leadership, and you all can then determine how it is you want to proceed. Who do you want to have involved in that process? SCJA is going to do the same thing. DMCJA will do the same thing. And in the end, what we're going to get, I think, is a much better rule going out for comment, correcting a lot of the deficiencies we see comments on currently. I am happy to take any questions that any of you might have.
Anybody have any questions for Judge Goodwin? Governor Williams-Ruth.
Thank you, Judge Goodwin, for being here. This is top of mind because it just came down, was the rejection of the revision to the Rule 9 intern. And that really was based, the only negative comment I could find was from the Court of Judicial Admin, your colleagues, objecting because they weren't going to have Rule 9. So under this new, would that, if this had been in place last year, would that have fundamentally changed the way that whole rule process happened? So where they could have been an amendment where maybe an agreement that anyone could be a Rule 9 in their second year as long as they took evidence during their first year summer?
Great question. And I think so. DMCJA objected to only that one component regarding having these first-year law students doing jury trials in courts of limited jurisdiction without having substantive evidence training. I think evidence at UW is second year. I'm not sure what it is at the other schools. So that caused us great concerns. We expressed that. I hope that wasn't the reason that the entire rule was rejected. Again, we see this issue with the proposal coming in, no edits from the Supreme Court Rules Committee or from the Supreme Court, and then just a wholesale rejection of the rule. So yes, I think we could have come to a compromise, eliminated that one provision. DMCJA would have supported that, and I think have a much better chance to pass that rule. There are some very good things in that rule. A lot of things that DMCJA liked. That was our only concern.
Yeah, I was going to ask you if you had any questions because you look very animated, Chief Disciplinary Officer.
Thank you, President Tollefson. I'm animated because, as some of you know, I often comment to this body when rule proposals come before the board, and not just regulatory rule proposals, all rule proposals. And I'll talk about that more later, but I do have a question relating to section F8 of your draft suggested rule, which involves rule committee proceedings being accessible to the public through remote viewing. I was wondering what your vision was as to remote viewing. Is that active live participation by the public, or is that just people can view it?
The Supreme Court proceedings, their en banc proceedings are not open to the public. So we did not feel like it was appropriate to suggest a change in their procedures. However, what we're looking for here is transparency. We're looking for members of the public to be able to see what is happening at the Rules Committee. It will be a TVW style opportunity to be able to view whatever that proceeding might be. Someone would be able to zoom in or remote in and at least observe the proceedings. And that's all in the name of transparency.
But that would be passive viewing.
It'd be passive
Then the
viewing.
commentary would be written commentary.
Exactly.
Anybody else have any questions for the judge, Governor Williams-Ruth?
No question, but I'll move for adoption of the proposal.
To be a
Be a
co-sponsor.
co-sponsor.
Is there a second?
I second.
Okay, it's been moved and seconded to have the Washington State Bar Association be a co-sponsor of this proposed rule. Which means I'll be signing a cover letter, yeah?
And Mr. President, if I could just speak to
Yes,
my
please.
motivation. As many of you know, I began my bar service volunteering for the Character and Fitness Board back in 2018, and have been involved in a multitude of different rulemaking processes, and anything that, and transparency is sometimes seen as a weaponized word, and it's not always. It's just not knowing what's going on and having that insight into what's done. And so I appreciate the fact that these proposed revisions intent is that it's not going to just be binary choices. That by the time we get towards the end of the road, I mean, look at how much amending we do and how much work gets done in sausage making, if you will, that to allow that process to continue beyond where submissions are made, it's no longer just once it's submitted, yes or no. Because again, there are always going to be other people that may come in with a different insight or impact or background that can raise a very valid point that people who had done the initial heavy lifting to get it there just didn't see. And so I really think that the proposal itself is sound, and I think it'd be one worthy of our co-sponsoring and endorsement by the association. So I would urge us all to support it.
Well, I've got other hands up before you, but that's okay. I think I've got Chief Disciplinary Officer Andy who'd like to make a comment. And I want to find out if the chair of our Rules and Procedures Committee, Mr. Rivas, who's online, is planning on commenting or not. Okay, I want to put you in the queue then too. So again, number one, number two is Governor Adwale. Then we've got Mr. Rivas, then Governor Higginson, and then Governor Clark.
Thank you again, President Tollefson. It is with some trepidation that I'm going to suggest that the board not serve as co-proponent of this proposal. And it feels strange suggesting that because I agree with everything Judge Goodwin has said. And I've read this proposal very carefully. And I think it has a great many excellent ideas that I totally agree with. More good ideas than troubling ideas. And yet, I want to go back to my background with rules. I think I can fairly say that with the experience I've developed with rule proposals and working with GR9 for nearly 25 years on behalf of the Bar Association, I am one of the leading experts in the state of Washington on General Rule 9 and compliance with General Rule 9, with the possible exception of acting RSD Director Bobby Henry, our own General Counsel Julie Shankland, and evidently Judge Goodwin. And I've been involved in every species of rulemaking on behalf of the Bar Association, not just regulatory. I've drafted and submitted GR9s for general rule changes, for rules of professional conduct changes, for rules for enforcement of lawyer conduct changes, rules for APR changes, for civil rule changes, for criminal rule changes. I served as staff liaison for the Court Rules and Procedures Committee and the RPC Committee, and on and on and on. And I say all of that for two reasons. One, the Washington State Bar Association is perhaps the most prolific submitter of rule suggestions to the Washington Supreme Court. The volume coming from the Washington State Bar Association is significant. And second, because over the years, I have developed my own thoughts and opinions about what is right and what is wrong with General Rule 9. And I've only had a couple of days to study the proposal that's before the board now. And while I agree with much of it, I do wish that a representative of the Bar Association had been at the table with the Superior Court Judges Association, the District and Municipal Court Judges Association, because I think we could have made this rule better. And I do not want to let the perfect be the enemy of the good. I would like the better to be the enemy of the good here. And I would prefer to see the Bar Association in the position of commenting on this proposal and perhaps making some additional tweaking suggestions as to how to make it better than be a co-sponsor, which makes the Bar Association's role as a commenter irrelevant because we're backing the existing rule, if that makes sense. And I'm also sensitive to the concerns raised by the chair of the Court Rules and Procedures Committee, Mr. Revis, and I'll obviously let him speak for himself, but I think there are a number of individuals around the Bar Association who might have thoughts about how GR9 ought to be amended. It hasn't been touched for more than 20 years. So if we're going to do it now, let's do it right. Thank you for recognizing me.
Thank you. Governor Adwale.
Thank you. I'm glad I'm going after disciplinary ND. I opposed completely what disciplinary ND is trying to do to this rule at this stage of the process. I'm the liaison to the DMCJ. I attended all their meetings, except for the last one or two meetings. And I know the statewide representation that the DMCJA has, both in the leadership and in the membership, and the serious thought and process that they give onto these rules. And as Judge Godwin stated, this is not just DMCJA, this is also Superior Court Judges Associations sign up on this. And what is, if our rules committee have any concerns to this, I would love to hear about those. But from what I've heard from disciplinary ND today is very knowledgeable in this area, but he cannot point to exactly one thing that is wrong. He is actually advocating to making it better. You know, we can't get a perfect. I've been the chair of the Access to Justice Board for the last 2 years. This is always the question about rules, because everybody have a good idea about how to make every rule perfect. But we never ever get to that stage where the rules, all the T's and the dots are all perfectly done. That is just my opposition to this idea that we shouldn't proceed with this because we can make it better. If there are any specific area that disciplinary chief Andy has to this particular rule, I would like to hear it. But arguing that we can make it better, therefore we should delay the process, we should not support it. And I'm appreciative that Governor Williams-Root moved the motion and is seconded by the president-elect able to this motion. And I'm fully in support of it for this rule to proceed as for for Washington State Bar Association to support the rule. We are not supporting the rule doesn't mean that we have to, every time we have a rule before us, that we be the driver of the rule. There are many rules that DMCJA sign on that is out of our own WISBA rules process that they agree to support on our behalf. That SCJ, should they, at every time when we make a proposed rule, should they come out and say, by the way, you didn't inform us about the process, and we would like to be at the steering wheel when you are making this rule. Therefore, this rule, we will not support you in making this rule. That is just not the way rules are made. If we have any particular objections to this particular rule, I want to hear it. I really want to see if there is any serious issues to why this rule should not. Does it meet with our goals and objectives? Does it meet with our mission? Does it champion justice? Does it stand for the rule of for the proper process of the court of the law? Yes. If there are any other issues with it, I would love to hear about it. Not just we can make it better, therefore we should delay supporting it. So that's my submission. Thank you, Mr. President.
Thank you. Chair Rivas is next. And before you get going, Chair Rivas, I do have a question for you. Were you on the Rules Committee a number of years ago when would have been President Majumdar? And there was a letter that was sent to President Majumdar, signed by the chair of the Rules Committee and also signed by me as the liaison, complaining about the lack of, the fact that the Rules Committee was getting ignored.
Yes.
Okay, I just thought I'd find out about. I mean, so this is pretty much an ongoing problem that we've had, right?
Exactly. Yeah. Thank you. Thank you. Briefly, I'm not going to add much more to what the committee put in its letter, since that was reviewed and signed off on by the membership. And I don't.
Okay, your voice is not. If you can get a little closer to your mic, maybe.
Certainly. Hopefully this is better.
A little bit.
We'll do the extreme close-up here.
Okay, that's great. No, perfect.
So I don't want to get out ahead of the letter that the committee sent, since that's what was viewed and voted on by a membership. I will start by saying that I think our committee in general, and I as well, agree with almost all of the observations that that Judge Goodwin noted, the problems with the current dynamic and how rulemaking is going. As you just pointed out, the issue with WISBA as a whole and the court rules and procedure in specific being sidelined or left out of the loop of the rules making process has been ongoing for some years, and I've commented on at least one or two meetings to the board on just that subject. So to the extent that this proposal does address that, that is something that we are in favor of. As pointed out in the letter, our committee felt that we simply hadn't had time to fully review the proposal. So I'm very mindful of Chief Disciplinary Counsel's distinction between supporting a proposal and co-sponsoring it. I feel like our committee came down on the side of we would support it, but without having spent some more time analyzing it, we weren't ready to co-sponsor it or to recommend co-sponsoring it, because the ability to suggest revisions or to make comments further on in the process as a co-sponsor would, as Chief Disciplinary Counsel mentioned, be a little limited if you'd already proposed it that way out of the gate. We did outline, I think, a few concerns. One of those was whether other stakeholder organizations would feel left out by where the line was drawn. I think that Judge Goodwin had addressed that already. I think one of the concerns was that, selfishly, as a part of the Court Rules and Procedures Committee, that if this rule were to be proposed and be adopted, we would want the Court Rules and Procedures Committee to have some role in the WSBA's membership, or the WSBA's appointee to the new committee, just to avoid being out of the loop, as has been the concern in the past. But really, I don't think I have all that much to add to what's in the letter, aside from the fact that we felt that this is a step in the right direction, or something that we would support generally or in spirit, but our members didn't feel like we had had enough time to go through it and sign off on all the specifics. That's all I have to say on that.
Thank you, Chair Rivas. We have Governor Higginson up next, and then, well, wait a minute, Governor Clark first, then Governor Higginson.
Thank you, Mr. President. I am not in favor of this motion, I'm sorry to say, and the reason I'm not is that we don't have a fiscal analysis. We have a fiscal impact statement that does say there'll be some additional cost to the WSBA, but we don't know what that will be. I just argued against a deficit budget, which the majority of you passed, and so be it. But we'll now be adding to that deficit if this measure goes before the Supreme Court and the Supreme Court agrees that that's what they want to do. I have not seen a proposal to remove, and I see Governor Boyd thinks that's pretty funny. So I'm sorry that her sense of humor is a little different than mine about spending member money. But I think that if we're going to consider this, we should be looking at what we might cut. If there's anything we have that's sort of duplicative of what this proposal would encompass, possibly we ought to take a look at that. And then maybe this proposal would be more attractive. But as it is, we'll be adding to the deficit. We'll be spending more money. We don't know how much. And we have nothing that we've looked at that we might sunset in order to accomplish what this proposal entails. So I am speaking against the motion, and I'll be voting no. Thank you.
Thank you, Governor Clark.
Thank you. I'd like to hear from Julie Shanklin and from Bobby Henry. Doug mentioned that he thought that they were subject matter experts as well as him. And I'd like to know if they have concerns, because it does kind of raise a red flag for me when Doug does have, so I mean, so yeah, thank you.
Well, mine is really easy because I did not review the proposal, so I'm not familiar with what it says. Sorry.
General Counsel Shanklin.
Thank you. So I wasn't prepared to speak on this topic. Thank you, Doug. So I guess it probably is important to think through being a co-sponsor or being a commenter, but I guess I would ask the presenter the question, if there were some suggested tweaks to this, Doug, are you wanting? Okay. I guess, if there were some suggestions to be made before the board decided whether to be a co-sponsor or sort of an active supporter and commenter, is that something that's on the table, or is this sort of a done deal?
I'm happy to respond to that. The challenge that we're going to face, I think, is the deadline for submission of rules. And here we are advocating for the rules to be followed. We can't submit something and ask for an exception, right? And so I believe it's October 15th is the deadline for a rules submission to the Supreme Court Rules Committee. And I don't think your board is going to meet again before that. What I can tell you is that our group, the SCJA and DMCJA members who are working on this, we would happily look at any suggestions that you might have related to making this a better rule.
Okay, so with that statement, I mean, you know, whoever said this earlier, maybe we can have our cake and eat it too while we're eating our cake. You know, it seems to me that many of the things in the rule are helpful. It is very concerning sometimes, or at least baffling, to just get oh, thank you for all of your work, but nope, without any explanation of, wait, is the whole idea a bad idea? You know, and you can't always tell from the comments. So that does seem helpful to me, but I will say that often there are unintended consequences of things, and sometimes it takes a while to think through what those might be. And I can't think of any right now, but we haven't had this for a long time and haven't been able to think through it. My only other comment is that when our WISBA Court Rules Committee develops a rule proposal, they have a very extensive stakeholder list that they send out these proposals to, and they are very attentive to the comments that they get from a very wide range of people. And that seems like an incredibly valuable process. And I haven't yet figured out if there's a way to keep that, you know, to take advantage of that here. And I would hate to lose that in this process. I don't know that I have anything else to say. Thank you.
Governor Clark, and then Governor, go ahead.
Okay, so Governor Higginson had raised that there may be some fiscal impact. Has staff done that at all? Let's see if there would be.
Director Lynch.
I was going to say that I think it's hard for us to know. It's just staff time, right? So no direct analysis of exactly how much staff time is going to be needed to implement has not been done at this point.
Thank you so much.
So could I ask a question? Maybe there's nobody in the room that could answer it, but the question is, if the Bar Association got involved, isn't it going to be some committee of volunteers that's going to be doing the work, not the staff?
I think, yes, oftentimes the volunteers will do the majority of the work, but typically there's a staff liaison that coordinates and provides information and schedules meetings, and also often steps in when volunteers are busy or overwhelmed or have a lot of things going on. And, you know, I think these are particularly hard to calculate because often the addition of a new work group is not going to require a whole staff person. But again, there's a cumulative effect of creating more and more entities.
Well, maybe I could just ask, why a new work group? You've got a committee already. It's called the Court Rules and Procedures Committee. Why would you create a whole new committee? Just asking.
Correct. Potentially not. And I think that's there's some uncertainty for us how it would be executed. It's also possible, I think, in a model where someone was just appointed, and we do have this model, I think an example would be, what's the court's technology committee? Yeah, I can't remember what it's called, but the court has, or AOC has, this technology committee that looks at the policies for the technology for the courts. And we have an appointed liaison that the bar appoints every year, and no staff support. Yes, JIS. And there's no staff support provided for that. They just go and serve on the JISC. So in a model like that, yeah, there probably would not be a staff ad.
I've got Governor, I think we've got Director Endy, Disciplinary Officer Endy, followed by Governor Stevens, followed by Governor Williams-Ruth, followed by Governor Adewale.
Thank you, President Tollefson. Very briefly, I just want to apologize to Director Henry and Chief Disciplinary, excuse me, General Counsel Shankland for dragging them into my little tempest, which was not my purpose. But the fact that Director Henry and General Counsel were not ready to speak on this issue is my point. Had someone thought to ask the WSBA's leading drafters about what they thought of this proposal, it might have come to my attention before this week, and we might have had those conversations and been able to participate in the process.
Thank you, Governor Stevens.
Oops. Can you hear me better now?
Yes.
Okay, good. So I guess I have a question, and it's perhaps procedural, but I'd like to know the difference. We rarely get, I think, requests for co-sponsorship, and I would like somebody to tell me the difference it would make instead of being a co-sponsor to simply be a supporter. I don't know if that makes any difference, but I'm curious why co-sponsor in this instance.
I'm happy to respond to that.
Please, Judge.
A rule that is co-sponsored by these three major entities, the three parties that are invited to vet the rules, the parties that are most involved in presenting rules to the Supreme Court Rules Committee, it's going to carry significantly more weight in persuading the Supreme Court to change their practice and policies. We would appreciate any positive comments on the rule, which we would have the opportunity to comment on that proposed rule. But I think a lack of co-sponsorship and co-proponentship from WSBA would limit the impact of the proposal.
Any other questions, Governor Stevens? No? Governor Williams-Ruth.
Thank you. One question. So I'm looking at your materials, and the draft letter that is on there has a date of April 22nd. Would you mind telling me, because I had assumed that this had been in the work for a long time, since it originally had a date of April 22nd of 2022. Can you just, do you remember when this process started with your associations of revising this?
Oh my. This process started, I was having discussions with Judge Forbes about this early on during her presidency of the SCJA. And so this process has been going on well over 2 years with our attempts to make some changes to the rule.
Okay. And again, this isn't meant to call out anybody, but this is frustrating for me in that we have liaisonships assigned. And if Doug is only hearing about this now, I look at that as a dropping of the ball on our side of people going to those meetings and coming back and reporting and saying, hey, Doug, Julie, Bobby, I think there's some things you should know. I mean, whenever I go to meetings, I am listening with an ear of, do I need to reach out to Director Nevitt? Do I need to reach out to Director Garcia, General Counsel Shankland? Do I need to be reporting back? It's not just me going there and smiling on the camera and saying, hey, I'm here on behalf of the BOG. So I would hope that the fact that we may have dropped the ball as being effective liaisons to these organizations not be a reason that we stop. I do have a question. And you mentioned our next meeting. It's interesting you say that. We passed as a board a bylaw revision regarding who can take up court rules and appoint them. Has that been approved by the court?
Yes, it has.
Okay, well, just so you know, Your Honor, in the event there were to be some changes and come back, there is a policy in place where this can be done without a special meeting of the Board of Governors, but by the Board Legislative Committee, which is able to be a little more nimble, less expensive, that if there were to be an opportunity to recreate something, there would still, even though it's short in time, there would still be an opportunity before October 15th, because we just, and I know you read our bylaws and are up to date, but didn't get this most recent edition that just was approved last month that allows for situations just like this. So all would not be lost if there was an opportunity to work on some revisions. Thank you.
Governor Dwale.
Thank you, Mr. President. I will respond first to the issue about dropping the ball. Oh, okay. Thank you, Mr. President. With regards to dropping the ball, this rule has been in the Rules Committee of DMCJA for the last 2 years. Okay, I was assigned as liaison a year ago. Okay, and so they just moved the rules to this stage. So nobody dropped. And I hope you're not presuming that just because we are Board of Governors members, that we are well aware of everything that the Rules Committee of WSBA is doing. I don't think that you know every rules that go through the Rules Committee, that you are involved in every section and every consideration of those rules. I don't think that that's your assumption, and I appreciate that that is not what you are trying to say. But what I stated here, and is very important for us to bear in mind, is the fact that these rules have gone through the process. They are willing to allow us to make input into the process if we have to. I'm just asking, if you vote the way you want to vote today and reject co-sponsoring this rule, you are going to need the DMCJA and SCJA in your future rules proposal. They are going to do the same thing to you. Will that be acceptable to you? Would you like to take that? Will you rather say, okay, we want to have an input into the process and give us some time to look at this? If you outrightly rejected being a supporter of this rule, they also have a right to be able to reject your rules next time because they don't feel like it's better played. But I have one question on the fiscal issue. And this question might be to Director Nevitt or to anyone that may be able to answer the question. Currently, the Rules Committee of Washington State Bar Association is supported by how many staff?
To be honest, I don't know for sure. I'd have to look at the budget. They do have one staff liaison, but that doesn't mean that there might be little pieces of other people that aren't assigned to it.
Okay, and how many rules do they consider per year?
General Counsel Shanklin says a lot.
How many members volunteer? Are those rules worked upon, or are those rules worked upon by staff or by volunteers? Providing staff support is different from writing the rules. No matter how experienced WISBA staff is, they don't get to write the rules. Thank you, GC. I see the General Counsel agreeing with me on that. So with regards to fiscal impact, it has to do with scheduling meeting, making sure that those meetings are set, that volunteers are available to staff those meetings. That is the fiscal impact that I believe some of the governors are asking about. Is that correct? Or are there paid lawyers, paid attorneys from WISBA that are assigned to rules committees to look through the rules and to prepare the rules?
So there is a portion of one lawyer's time from the Office of General Counsel, who is assigned to assist the Rules Committee. She does things that they ask her to do. Could you go find a history of this? Could you, right? Could you assist us in this way? There is also a portion of a paralegal's time who, so they review the rules on the schedule as published in GR9, right? So they're looking at specific rules on a 4-year cycle that's kind of repeated over time. That's part of what they do. Then they review rules that this Board of Governors sends to them and asks them to review that come in from all over the place. So that's what I'm saying. They review a large number of rules, and part of what the staff people do is sort of put those all in a place where the members of the committee can get to them, organize them, right? And then gather them up, send them out to all of the stakeholders, keep track of where all of those stakeholders are, how to get in contact with them, and, gather up the input, provide it back to the committee. That's the kind of support that is provided.
And I appreciate that. Mr. President, just one last question, and then I would cease and desist.
Go ahead, please.
Thank you. So currently, are there rules that they are working on right now that they would have to set aside to focus on these rules and the urgency of it that are time limited? Would us asking them to consider rule within time means that they have to set aside some work that is also urgent, that we have to provide extra staff to be able to do?
I think the chair of the Rules Committee might actually be in a better position to answer that than I am. I'm not that close to the work that they're doing that I could comment on that.
May I respond briefly to the fiscal note issue?
Can I see if the chair of the Rules Committee is still on there somewhere? Let him chime in first, and then Judge Goodwin, please. I don't know if he's still on. Chair Rivas, are you still there? I think he dropped
Yes,
off.
sorry, I was searching for the mute button.
Okay. Remember, you got to get close to the mic.
You remember that.
Hate to have to ask you to do that, but that's the only way
After
it's
all that wind up, I'm sorry to say, actually, I don't have a specific comment. I'm sorry. What was it exactly that you were looking for my comment on? I apologize.
Governor Adewale, was your question, wasn't it?
Yes, it was my question. Are there any rules that you and your staff are currently working on now that would need to be set aside to be able to focus on working on this rule to see whether we can be a supporter or be a sponsor?
No, no, I don't believe. We are working on several proposals right now. I do not believe that we would have to set those aside to focus on this.
Thank you. That's my question. My question has been answered. So the fiscal impact would not upset anyone. Would not upset the budget. So there is no fiscal impact other than what has already been assigned. Thank you.
I think I've got Judge Goodwin wanted to respond to the fiscal note issue.
Thank you. Keep in mind that this is not going to change anything about how your various committees work. They're staffed with AOC support and other staff support. Nothing's going to change in any way. We're not going to increase your workload for your various committees. You will have a volunteer from your organization, a WSBA member, who will simply serve as a conduit to be able to make sure that the information coming from the suggested rules is farmed out to the various rules committee. While that may involve a small amount of staff support, DMCJA has looked at this, and it is an insignificant fiscal impact to simply have a volunteer as the liaison.
Thank you. Governor Williams-Ruth. Okay, Governor Stevens.
Thank you, Mr. President. I was just trying to understand this. And by the way, I think this is really not so much a rule, but the process in which rules are to be adopted with back and forth that allows rules to be put in better shape before they're put out for comment. And I think that's what I heard. I am concerned that as far as I can understand, our chief disciplinary counsel, our general counsel, and Mr. Henry, we're not all prepared to actually speak to this. But I was just wondering, I understand you have your October 15th deadline, but that's actually to start the ball rolling. What I'm thinking about, because I would tend to actually vote no on this, because actually without good input from the people I mentioned, I don't feel comfortable. But I wonder if there's a way to get there, which would be actually to postpone action on this, or especially our staff experts to really work. And even though you have submitted your proposal, since that itself is going to be a process, it would seem to me that there still may be time at a later date for WISBA to actually say, we co-sponsor this proposal, or make our comments in support. And so I'm just wondering if that's a way to do it. What I would find unfortunate is if, because of where things are right now with people that I would rely on for advice, we voted it down. I'd rather not vote something down as opposed to postpone action, let you go forward, and then perhaps we come back and actually, with other considerations, take the vote that very well may be favorable to you in terms of co-sponsorship.
I don't know. Is there anybody that wants to try and answer that? I don't have an answer.
I think it would have to come. May I be recognized,
Yes, please.
Mr. President? I don't know if Governor Williams-Root is willing to take a friendly amendment to hold off approving this rule and send it to the Rules Committee for
The Rules Committee?
for the WISBA Rules Committee
Sorry, it's already been there.
to provide input on it and make some recommendations for the legislative committee, as Governor Williams-Root suggested, for approval, and take it through that route rather than the board. I would really love to see the board be a sponsor, but if the intent is that it should go through the Rules Committee and get vetted before we become a sponsor, then the friendly amendment is to have that go through the rules, and then the rules can request that the legislative committee approve WISBA as sponsor, or reject approval and just support, depending on what the rules committee made. That's my friendly amendment to the motion, to go through that route instead of us voting no on this motion today.
Governor Williams-Root.
And I've been trying to read the facial expression and eye twitches of Council MD to see if that is an acceptable workaround.
May I be recognized?
Yes, please.
I would rather see this board endorse and be the co-proponent of this very, very good proposal today, then create a fire drill and a lot of additional time and effort and work to make a very good proposal somewhat better. Maybe 20 years from now, we'll revisit this again and we'll perfect it. Or maybe during the comment period, even as proponent, I don't know that this has ever been done before, we could still submit some additional commentary to the court, or maybe I could do so independently as chief disciplinary counsel.
Okay.
But I withdraw, not that I vote or move or anything, but I withdraw my stated concerns for present purposes.
Governor Stevens, do you have any other questions before we move on to the next person who's in line there? Okay, so we're back to you, Governor Williams.
So I'll just say that I kindly reject the friendly amendment and again, because even if we vote this down,
I
they can
kindly
still-
withdraw my friendly amendment.
because even if it gets voted down by the board, there's still the opportunity. I mean, there's still the other avenue if a resubmission is submitted before October 15th, where the BLC could be called into session. So I would like to just see a vote on the motion, please.
Any other comments, questions? Oh, yes, Governor McBride.
Thank you, Mr. President. This is one of those good discussions because I started in one place and I ended up in another, which I think is a good sign. So I was initially a no, and as I listened to this whole discussion, what I realized is I was feeling pretty protective of the Court Rules of Procedure Committee and that this was a diminishment of their role. And knowing people that served on it, I felt like I'm not sure I agree with that. But the closer I look at it, the more I listen to people, it seems in some ways we more want to improve that initial vetting by the Supreme Court. And I'm a big fan of trial court judges being very involved in court rules. And sometimes the Supreme Court has a trial court expertise, but there's a number of justices that haven't been trial court judges. So when I start thinking about that way, I start liking this proposal and the involvement of the district and court judges, Superior Court judges, probably more than, quite frankly, I like the involvement of the State Bar Association because we have a Court Rules and Procedure Committee. So I think I'm leaning towards a yes now, and I was a no. And so I guess we'll see when we vote, but I thought I'd share that with everybody because it doesn't happen that often, but the conversation's been great and I appreciate it.
Any other comments, questions, or anything before we vote? I'm guessing everybody's ready to vote. Governor Abell.
Aye.
Governor Adwale.
Aye.
Governor Angelville.
Aye.
Governor Boyd.
Aye.
Governor Clark.
No.
Governor Couch.
Aye.
Governor Dresden.
Aye.
Governor Higginson.
No.
Governor McBride.
Aye.
Governor Peterson.
Yes.
Governor Pertzer. Governor Sayani. Governor Stevens.
Aye.
Governor Williams Ruth.
Aye.
I have 10 yeses, 2 nos, and 2 not voting. Is that what you have, Executive Director Nevin?
Yes.
The motion is approved. Judge Goodwin, thank you very much for being here today and providing all that information that you provided us. It was very helpful in getting the board to come to a decision today. Thanks
I
very
think there's
much.
no lawyer or trial court judge out there who dislikes this kind of discourse and this back and forth. And so it's been a great pleasure to sit here and watch all of you work. I will tell you that our submission is not due until October 15th. And I was very sincere in my offer to work with anyone at WSBA with suggestions related to making this an excellent proposal if you have some concerns about that. I think you all have my contact information. I'll make sure and get that out so we can consider that. And our committee, the SCJA DMCJ Joint Committee, would be very pleased to work with you on that. Thank you so much for your support. I really appreciate it.
Judge, could you, when you're getting your contact information out, could you just let everybody know who is on this joint committee from the 2 different associations?
Yeah, I'll be happy to.
Okay.
I'll send that
Okay.
in a group email to you.
Okay. Thanks you so very, very much.
Thank you, folks. I appreciate your help.
Okay, folks, we are sort of behind schedule, so does anybody want to take a 5-minute break? But we've got two presenters here from our real estate brokers that would like to share information with us. Does anybody want to take a 5-minute break? Well, I got some people else. People are voting with their feet, so.
So we have to take a 5-minute break before swearing in anyway. So if we take one now, we're taking another one in an hour. And all I'm saying is it has to be 5 minutes because we're way
Yeah,
behind
so
schedule.
just 5 minutes. 5 minutes and we'll be right back, okay? 5 minutes.